Hello neighbor, I'm Robert Burns, and it's such a delight to be back with you for yet another edition of Sound Off Louisiana. And I know it's been a little while since we've had one of these little friendly chats, and quite a few developments have happened, such as Coach Good up in Monroe and all of the fallout from that. And we're so very thankful for the huge popularity of that post. But I believe this is the first time I've been back with you with one of these little individual chats, if you will, since we had the situation with the ATC Commissioner Troy Hebert and Brett Tingle's litigation that involved certainly some interesting text that Mr. Tingle sent. And today's feature will be somewhat similar in nature in that I've seen social media posts basically wanting to try to find out what's going on with this Antiva document, and it's, if you look at coverage, what limited coverage there's been, particularly by the mainstream media on the national level, i.e. Newsweek, I read that article and I didn't have the slightest clue what was going on here. And I think that's a fault of kind of drive-by journalism, which, I know sometimes folks say, well, my posts are a little lengthy, and, that the current generation will only last for 2 minutes. That's not my brand of journalism, okay? And so I'm not going to appeal to that segment. So if you want the little flash dance, that's not conducive to what I do. So I'll just get that out of the way, because I think that's a fallout from trying to do that type of flash journalism. You leave readers or viewers wondering what in the hell is going on. All right, so let me enlighten you with regard to that for those who have been curious on that particular document. Let me first of all say, let's go back in time. We had the Alton Sterling incident back in 2016. I'm certainly not going to rehash that, because you have to live in a cave if you don't remember the Alton Sterling incident. But I will say there was a federal lawsuit filed by a civil rights attorney in New Orleans by the name of William Most, and we're going to give you a link to that lawsuit. I'm not going to go into all of the specifics of that litigation, because that's not the main focus of our post today. We'll also give you links for the rulings that were made with regard to that litigation, which is now, I don't know, about a year and a half old. But there were a number of motions made by the key defendants in the litigation, and we will give you direct links to the rulings that were made last week, as well as quick little parenthetical disclosures of the basis upon which the judge made those rulings on the requested motions. Now, originally that lawsuit involved the East Baton Rouge Parish Sheriff's Office, and it involved the Baton Rouge Police Department, but subsequently Louisiana State Police, as well as former Colonel Mike Edmondson, as well as current Colonel Kevin Reeves, were all dragged into the litigation. And around May of this year, the civil rights attorney, William Most, decided to start making some public records requests of Louisiana State Police, ostensibly not to do with that lawsuit. And the public records requests involve searches for some racially charged phrases, some of which I'd never heard of, to be frank with you. And we're going to give you a little display right below this video of what the list of the racially charged phrases that they wanted searches done for, or documents that would have these inflammatory words in them. Of course, the N-word being chief among them, but quite a few others, watermelon, things of this nature. And it will show you a preliminary search that state police did, the number of occurrences that these happened in strictly in emails, and the number of mailboxes in which these words were found. And so upon having that initial search, the head of the legal department of state police for this type inquiry, Faye Morrison, had responded to Mr. Most saying, look, your request is overly burdensome. In fact, she said it would shut her entire office down for 2 weeks. But there got to be some back and forth. You're welcome to go look at, we're going to give you a link for the actual, well, I'm getting ahead of myself, for another lawsuit that was filed. But we'll give you the link for the back and forth that went between Mr. Most and Ms. Morrison about, we got to figure out something here and let's come to terms on this. But at any rate, she had given that preliminary search. It showed these number of occurrences of these key words. But she also, in an attempt to try to provide some level of cooperation here, well, let me just say this. First, Ms. Morrison asserted that, look, you're trying to circumvent doing discovery in the litigation that I just mentioned to you, the first lawsuit, the Alton Sterling related lawsuit. You know, he asserted that he didn't. They had a hearing in federal court involving that lawsuit about whether or not to proceed forward with whether or not they should proceed forward with the public records request. The judge said that, the judge, by the way, is Judge Digger Revelle, is the same one that handled the Brett Tingle ATC situation. He said that, look, this is separate and distinct. Go ahead and fulfill the public records request. If he chooses to utilize material gain from that public records request, I will insist that he go through the proper discovery process over here with this litigation. That all happened, I don't know, excuse me, around mid-July or so. They're starting to work on potentially knocking this out. Mr. Most was frustrated that he didn't feel like she being Miss Morrison. In fact, he accused her basically of sitting on her hands for a couple of weeks, which is interesting because in a court hearing I'm about to tell you about, he wanted to know what she had been doing, and she could hardly contain herself when she said, "You want to know what I'd been doing?" And those of you who have watched our broadcast religiously would know that she was extremely tied up in appeals hearings on the Vegas 4. That was a 4-day process. I won't go into all that, but I did catch her reaction when she said, "You want to know what I've been doing?" But at any rate, I said all that to say this. In this spirit of cooperation, she didn't really give much thought to. She printed out quite a few emails, provided them, I think, electronically, and several of them, there was nothing in the email, but there was strictly an attachment that was this Antiva, if I'm remembering right, this full list of Antiva.doc, which is a Word document. Well, that perked Mr. Most's interest. Apparently there's a strong demand for that document. It piqued his interest so much that he said, look, I tell you what, let's do this. You give me that document, and we will consider you can forget the rest of my public records request. You give me that one document, and you can forget everything else I've asked you for. Well, Miss Morrison, basically knowing that, hey, oh God, trying to fulfill what he wants on here is just going to be extremely labor intensive. You know, as she said, would shut her office down for 2 weeks minimum. So she quickly jumped on that deal. She said, "You got a deal, okay?" And so she said, "You got a deal." That document apparently contained stuff, and I'm just saying stuff because I don't know the specifics, nor am I going to delve into it, from what was acknowledged to be a fake website in which visitors to it felt free or were motivated to post anti-Donald Trump comments. And of course there are plenty of Donald Trump detractors, and so no doubt it got quite a bit of attention. And so he said, if you give me that one document, we'll consider this whole matter over with on the public records. Well, how easy is that? You supply one document. So she had said deal. Well, Morrison readily, we had a hearing. Boy, this is tough to try to keep in sequence. Morrison, essentially, it was established she didn't have a clue what this document was. In fact, one of the emails say that, look, I don't have a clue what this is, but I don't see any reason why you shouldn't be able to have it. Well, she spoke a little bit too soon, because it turns out the document, which is a Word document, had been obtained by an external source who was initially viewed as a suspect by state police in criminal matters. Now, he was brought in, and 8 days after he was initially viewed as a suspect, he was debriefed 8 days later, and he was given the status of being a confidential informant, or as they like to call it, CI for short, as I saw in the courtroom. And so what happened is a gentleman named Troy Dupuis at State Police provided this document to a gentleman named Steve McGovern. McGovern finds out that Morrison has agreed to give this thing out, and he says, oh, no, you cannot go give this document out. It is part of an ongoing criminal investigation. So Morrison now has to go to Most and say, look, I know I told you you could have this, but I was wrong. You can't. It's part of an ongoing criminal investigation. Oh, at that point, a gentleman named Thomas Frampton gets involved in the whole thing. He teaches out at Harvard University. He's a fairly young gentleman, 34 years old, and he says, now look, I don't believe you can withhold this document. You need to turn it over, yada, yada, yada. Well, they were emphatic that they were not going to turn it over. And so a lawsuit was filed, I believe, on August the 29th, maybe the 30th. We're going to give you a link for that lawsuit, too. It was actually a writ of mandamus, which is an effort to force a governmental entity to do or refrain from doing a certain action. In this case, they're trying to force the governmental entity, namely state police, to turn over this one document. Let me just say this, whenever you file for a writ of mandamus, one of the key elements is it's got to be demonstrated that the governing authority has no discretion. They're extremely rare that a writ of mandamus would be granted, but at any rate, there was a court hearing held on it on Wednesday of this past week, Wednesday, September the 12th, and most of what I've just relayed to you involved testimony either by Mr. McGovern or Miss Morrison, who were the only two witnesses who were called in that lawsuit. And so McGovern is up on the stand, and of course he's being questioned about, because there's two elements here. If either one of them pass, I guess I should do like this, there are two elements. If either one of them are successfully asserted, the judge is going to be duty bound to deny providing the public record. The first of which is it going to reveal the identity of a confidential informant, CI? Well, it was pretty well established that it would not compromise the identity, because McGovern stated under the on the stand under questioning by Mr. Frampton that to his knowledge a hard copy printout of that document is not going to contain the CI's name. So let me say this. The judge, they reached an agreement that the judge is going to go look at the document, and it was in a binder that was pretty doggone thick, so this is not some little 1 or 2 page document. Go and examine the document in camera. Judge Morvant does that. He comes back out, and I'm pretty much uttering his verbatim words. He said, I don't know what the hell it is I just looked at. He said, this is nothing but a garbled up mess. Now, he did admit that he's not very computer savvy in terms of the social media world. There's a bunch of hashtags, and he had no clue what they meant. It makes me feel a little better, because I've only recently been told that I've got to beef up my Twitter presence, because the younger generation, as I'm being told, that Facebook is, well, that's your grandfather's social media. And so I'm making some efforts to do some stuff on Twitter and try to learn how the game works. That's one area where I guess C.B. Forgotston and President Trump, though neither of them are young. I'm going to stall for a second while that helicopter passes by. That they did exploit the social media phenomenon in the way of Twitter, which I have been very much deficient in doing. But at any rate, he basically said, look, I don't know what the hell this is I just looked at. You know, it was just a garbled up mess from my vantage point. And Morrison said, well, Your Honor, that's exactly why I didn't see any issue with releasing it. And she said, having said that, I will never make, she said, it was ignorance on my part. And the ignorance is the word that she used. Now we've got a gang of geese that have come flown in, and we'll be chiming in to some music in the background. But she said that it's one of those days when it rains and pours, I guess. Helicopter, now we got geese. She said that she was ignorant of what the significance of that document. She said, I'll never make that mistake again in, I guess, basically not checking base with the investigative team, that being Mr. McGovern, who, or whatever his rank is, you have to forgive me, I didn't pay attention to any of these ranks, over at a division of state police called the Fusion Center. I believe that was it. We'll give you a link for that segment of state police. Boy, everything is going wrong. because it's maybe about to rain. But at any rate, so she said she didn't see a problem with releasing it, but clearly she said she had made an error. Mr. McGovern, or Trooper McGovern, I'll just say that for the generic, he had said that this CI is no longer a CI with state police, but that he does serve as a CI for another agency, which is now the lead agency. State police is strictly a backup. Frampton asked him to identify the other agency. He said, absolutely not, I cannot do that. Frampton would not even give, McGovern would not even give whether or not it's even located in the state of Louisiana. Frampton did say, all right, did you ever let this document get outside of this close circle of this fusion center? McGovern had said he did not. However, it was interesting that later he did admit that it had been provided to the Lafayette sheriff. I think that was kind of that's just my speculation, that there was probably an attempt on Frampton's part to try to rule in or rule out Lafayette sheriff being the other investigative agency. However, sources that have far more knowledge of me about how this stuff probably works have said no, it was much more likely that the other agency is the U.S. Department of Homeland Security. We're not going to know because he won't tell us, but I'm just giving you that for informational purposes. McGovern did say that not only is it an active, ongoing investigation, but he said he checked with the lead agent for the other agency just the previous week, and that he had stated that it is active and ongoing, and volunteered that there had been an arrest made in August of 2017 involving numerous felony counts. And so what this all boiled down to is the judge had to make the two assessments that I just told you about. Would it compromise a CI's identity, or was it part of an ongoing investigation? The judge ruled that the document would not compromise the identity of a CI, but he said state police had clearly established that there was an ongoing investigation, and so he was going to deny the writ of mandamus, and that state police would not be mandated to have to produce the document. And at that point, Mr. Frampton, now he's 34 years old, and of course, when you hear the words Harvard, and he had a background in previous to, he got his both master's and bachelor's degree from Yale University, got his doctorate, his JD from University of California, Berkeley, and had worked in the public defender's office in Orleans Parish. And we're going to give you a little link for an article where he is quoted extensively about numerous problems he alleges in that public defender office in Orleans Parish. But at any rate, I said all that to say this. He's got all of these qualifications. I think anybody would acknowledge that he's a sharp individual. And, you know, when you hear the words Harvard, you know, you automatically start thinking, okay, probably way above us. But I've said it before and I'll say it again. There's no experience, no substitute for being a veteran courtroom trial person. And once the ruling came down from Judge Morvant, well then Frampton said, Your Honor, I'd like to make a motion to seal that Antiva document so that if we make an appeal before the First Circuit Court of Appeals, I certainly would want them to have the right to examine the document in camera just as you did. Judge Morvant was quick to inform him that, well, I waited and waited for you to make a motion to introduce this document as evidence. You never did so. Y'all wanted me to look at it in camera. I looked at it in camera, but there was never a motion made to introduce it as evidence. So since it's not in evidence, I'm not about to entertain a motion to seal it. I think Mr. Frampton realized that, you know, like I said, there's no substitute for experience in a courtroom. So he said, well, I'll get with state police counsel and see about us jointly agreeing to have it admitted under seal. And he said, well, that's going to be up to y'all. My guess is don't look for an overly receptive response to that particular request, Mr. Frampton, but that's just my own opinion. And without it, it's probably going to make doing an appeal fairly difficult. So you probably set up a pretty high hurdle for yourself to have to clear. Now I'm just going to wrap this up because it looks like it may pour down rain on me by saying that Ms. Morrison did state that her office had in fact been shut down for about 2 weeks to try to get as many emails out to Mr. Most as she could. And please don't hold me to this figure because I'm not positive I heard her right. I believe she said 1,400 was the number that she had supplied to him on the day of that hearing, I think by way of a thumb drive. I did hear this number right. She said we have withheld 1,500 emails because we have employees that while they shouldn't have been doing this, they put personal information into the emails. Things like, well, this is my daughter's grades from last semester. I'm so proud of her, and so forth and so on. And she said, again, this kind of stuff should not be put in work emails, but it causes a problem for us because I would imagine she has to do one of two things. Either get the okay for that employee to go ahead and allow that to be provided, or then if the employee won't agree, she got to redact it. So there were about 1,500 emails that have been withheld based on that. You could see Ms. Morrison has been under an enormous amount of stress and fatigue from this, and I'm sure the fact that she initially agreed to provide the document only to have to turn around and say that hey, we can't give it to you. I'm not going to make any judgment about whether or not. In closing arguments, you got to realize Mr. Frampton was pretty doggone aggressive in what is his accusatorial language about state police in saying that, well, it's one of two scenarios. Either you people are incompetent by using material from this fake website. By the way, the judge did ask, well, okay, if it was available on some website, why? That would seem to me, you would have already had it from off the website. What's going on that you would need to go through all this to get it? And Frampton had said, well, Your Honor, this is a Word document, so as you well know, or would know, the stuff could have been obtained from the website and then uniquely tailored for state police's purposes. Because let me emphasize, what they are alleging is that state police is targeting individuals who may appear on this list. Ms. Morrison was very emphatic during arguments while the judge was looking at all this in camera that has not been the purpose of their list. She also, I want to say this, I'm glad I stalled for a little bit to get my mind back together. She also said of all these emails that you're seeing, and it's a staggering number, about, in the number of emails that contain these racially charged words, as well as the number of inboxes, that may be deceptive because Ms. Morrison testified, and she's under oath, so she got to tell the truth on this, that it had been her experience that a vast majority of those were incoming emails from external sources, most of them political in nature, which would mean these words didn't originate from state troopers out there. But at any rate, Mr. Frampton had said either you people are incompetent in not recognize this being a fake website and are targeting people, or it's even more, as he used the word frightening, he said it would be frightening to me to think that you are actually using this for criminal prosecution. And Ms. Morrison, in her closing arguments, basically reminded the judge of how assertive this young 34-year-old attorney in the name of Thomas Frampton had been in his pleadings, and that she said, Your Honor, we have demonstrated in quite authoritative fashion that there is a criminal investigation going on, and that arrests have been made as recently as August of last year on a number of felony counts. So I'd have to say that Mr. Frampton may have got a little bit of a comeuppance, especially in his boneheaded move of not filing a motion to even introduce the document as evidence. So that will help clarify what all of this Antiva document and what all's been going on. And I hope, well, let me tell you this, I don't have to hope you found it more useful, because I'm not even going to provide you with that Newsweek link, because, God, you couldn't glean anything from it. I will say this, the Louisiana Record just came out with an article on it. They don't have the information that I just gave you, even though the article came out 3 days later. There was nobody there to cover this writ of mandamus. No media outlet, period. So once again, just as for the Brett Tingle situation, if you're not happy with the information I just gave you, contact some of these, WBRZ, WAFB, The Advocate. They all get a lot of money, to cover this sort of stuff. But for some reason, it seems that the focus is more, oh, we got a linebacker for LSU that sneezed, have 5 reporters stuck in microphones in his face. Do you think you're coming down a cold? You think you'll be eligible for the next game? Are you going to be okay? Do you have the flu? You know, I'm exaggerating a little bit, but I'm just telling you right now, and I think that's only going to be intensified with the departure of Jim Mustian from the Advocate on the greener pastures up in New York. That it's sorely lacking. The kind of coverage that I'm giving, that Sound Off gives, it's just sorely lacking, and it's very frustrating. But it's what caused me to form the blog. We're getting more and more viewers, subscribers, so clearly there is a demand for this sort of thing. I thank you for it, and I hope that you found this feature to be quite informative. We'll look forward to bringing you another Sound Off Louisiana feature again in the near future. Apologize for all the geese when they came in here. There's a school of about 12 of them over there, and boy, did they make some noise when it first came in. Wind whipped through here, blew 2 of my little note sheets away, but we made it on through, and I am enjoying this cool breeze, and we will have another Sound Off feature for you again real soon. Thank you again.